And greetings. Welcome to Warrants, Searches and Seizures from American Jurisprudence. I'd like for y'all just to sit back, relax. Let's get into this one. This was actually a request from one of our subscribers. And so, at their request, we're going to go into Warrants, Searches and Seizures. Zoom in a little bit here and let's get going. So this is from American Jurisprudence, second edition. This is a 2011 supplement update, so it is quite old. However, a lot of these principles are common law, so you'd have to look and see if there's any recent changes to the cases we bring up, but the principles should still stand. So let's get into section 299, where we're starting with this. And this is under searches and seizures. And we're going to go over the warrants. The Fourth Amendment right to be free from unreasonable searches and seizures includes the right to be free from the unreasonable execution of a search warrant. A search warrant's execution must be conducted reasonably, and the search and seizure must be limited to the scope that is permitted by the warrant. A search warrant can be based on the best of probable cause. But if the officers who execute it overstep its self-contained limits, the execution becomes unconstitutional. Once probable cause exists and a valid search warrant has been issued, an officer's subjective intent in conducting the search is irrelevant, and a court simply asks whether the police confine their search to what was permitted by the search warrant. All right. So if everyone can hear me clearly, please let me know. And we're going to continue on here. Going to be checking the chat periodically. So if there's any questions or any clarifications, please go ahead and pipe up in the chat. And let's proceed. Here's an observation. The process of carrying out a search or seizure pursuant to a search warrant is generally referred to as executing the warrant. So here's a good observation. We want to mention that the process of carrying out is called executing the warrant. Although the manner by which to execute a search warrant is generally left to the discretion of the officers executing the warrant, possession of a search warrant does not give the executing officers carte blanche as to its execution, and the manner in which a warrant is executed is always subject to judicial review to ensure that it does not traverse the general Fourth Amendment proscription against unreasonableness. When an officer executing a valid search warrant for one item seizes a different item, the court must be sensitive to the danger that officers may enlarge their specific authorization furnished by a warrant or an exigency into the equivalent of a general warrant to rummage and seize at will. So a general warrant. Practice tip. So before we continue here, I just want to remind everyone this is not for any kind of legal, lawful, professional, or financial advice at all. This is strictly for the educational, entertainment purpose of this video here on YouTube. Don't do this at home. But other than that, here's a good practice tip. A court reviewing the propriety of the manner of executing a search warrant. So the propriety of the manner of executing a search warrant must review the law enforcement agent's actions from the perspective of reasonable agents on the scene. Reasonable agents. Good terminology here. Who are legitimately concerned. Another one. Reasonable agents. Legitimate concern with not only doing their job, but also with their safety. Of course, their safety, officer safety. Warrants authorized on the basis of allegations involving piecing together a number of items that are not by themselves incriminating, but have an interlocking character that constitutes the evidence of a crime, necessitate an appropriately flexible analysis when determining the reasonableness of their execution. Thus, it may be reasonable for police to search a defendant's apartment pursuant to a warrant, even when the defendant is not present, and there are no exigent circumstances. It may be reasonable. So we got some footnotes here, and these are cases 2003, 2008, noting that that executing a warrant is sometimes referred to as serving the warrant, either in court decisions or in statutes. Interesting one there, huh? In conducting an actual search of seized computers and disks, considerable discretion must be afforded to the executing officers regarding how best to proceed with the search. Oh, right. Massachusetts, Connecticut, okay. All right. And the supplement here are cases. Those who execute lawful search warrants must do so in a reasonable manner. So even if it's a lawful search warrant, it must be executed in a reasonable manner. It is generally left to the discretion of the executing officers to determine the details of how best to proceed with the performance of a search authorized by the warrant, subject, of course, to the general Fourth Amendment protection against unreasonable searches and seizures. Subject, of course, to the general Fourth Amendment protection. And that was 2010, Wisconsin, so that's rather recent considering this subject here. All right, let's bounce over to the chat here, see if anyone's here. And Audit Them says that we are from the government. We are here to help. You're really scaring us there, Audit Them. I'm going to have to delete that comment. That's very scary. There's some very scary words. Some of the scariest ones in the English language. All right, let's proceed. Oh, here we go. Consent to search given under coercive circumstances, and that's in 26 AmJur Proof of Facts, second edition. So there's some pretty good ones in here too that we can follow up if audience so decides. All right, we're on to section 300. Who may execute a warrant? An officer requiring the aid of a private person for the execution of a search warrant must be personally present with such person at the time of its execution. So if the officer requires the aid of a private person, pay attention, private person, for the execution of a search warrant, requiring the aid for execution, the officer must be personally present with such person at the time of its execution. Here's an observation. Although adequate police supervision of civilian assistance ensures that a search warrant is properly executed and its scope is not exceeded, the required level of supervision varies depending on the circumstances. So how much supervision depends on the circumstances. Officers ordinarily may not execute a search warrant at a place which lies outside of their jurisdiction, but they may obtain the authority to execute the warrant if they are accompanied by an officer whose jurisdiction includes the premises in question. Interesting. City police may have countywide jurisdiction to execute search warrants. A city police officer acts within his or her territorial jurisdiction when executing a search of a defendant's business premises located outside the city limits, but within 1 mile of the city limits. Similarly, a city police officer has authority to obtain and execute a search warrant in another city when that officer's commissioned as county deputy sheriff. So when that officer's commissioned as county deputy sheriff, which the officer had before joining the city police force, is still in effect at the time the warrant is obtained and executed. Wow, that sounds like a real deep technicality. A police department's use of National Guard soldiers who are not in federal service to execute search warrants does not violate the Federal Posse Comitatus Act. Oh, wow. National Guard soldiers who are not in federal service. As long as they're not in federal service. Wow, that's a deep one there. Officers from another jurisdiction may accompany officers conducting a search pursuant to a warrant without tainting the evidence uncovered in the process, even when the officers lack probable cause to support issuance of their own search warrant. So as long as they're accompany officers conducting a search pursuant to a warrant and without tainting the evidence uncovered in that process, even when the officers lack probable cause to support issuance of their own search warrant. But they can't be tainting the evidence. Interesting. And here are those cases. All right. And we're on to the next section, federal law. Under federal law. Let's check on the chat here. Ola to Beachside, Redneck. And Bill Thomas, greetings to you as well. And El Perro's here. Great. Yes, it's a business, all right. Sure is. All right, so let's get back to the document here. Well, that was a quick one here, isn't it? Here we go. Under federal law. Under federal law, a search warrant must be issued to an officer authorized to execute it. Under federal law. So the officer must be authorized. The warrant may be served by any of the officers directed to serve it by any other officer authorized by law to serve such warrants, but not by any other person, although other persons may aid the officer if required, and if the officer is present and acting in the execution of the warrant. Here's another great practice tip, which is one of the nice things with American jurisprudence. The federal statute does not require that a search warrant be directed to a particular officer by name, so long as the warrant is directed to the civil officers of the United States authorized to enforce or assist in enforcing federal law or otherwise authorized to serve search warrants. Officers, agents, and inspectors of the Federal Bureau of Investigation are empowered to make seizures under warrants for violation of federal law. Internal revenue agents may be designated in the warrant as the officers to make execution thereof, as may be agents of the Bureau of Alcohol, Tobacco, and Firearms. Oof. I gotta rinse my mouth out after saying all those words. Okay, we're on to the observation. Execution of a warrant by state law enforcement officials does not invalidate the warrant and the subsequent search and seizure when there was no evidence showing either that the search would not have occurred if required to be executed by federal officers or that there was a deliberate attempt to violate the federal rules of criminal procedure. So, execution of a warrant by state law enforcement officials does not invalidate the warrant. Interesting. Now, the subsequent search and seizure, when there's no evidence showing either that the search would not have occurred if required to be. All right, so there's another technicality here. And persons unauthorized to execute a search warrant may be present and assist in its execution. May be present and assist. However, an officer requiring the aid of a private person, such as a victim of a crime, must be personally present with such the person at the time of his execution. This is an interesting distinction here because persons unauthorized to execute a search warrant may be present and assist. But if they're requiring the aid of a private person, authorized or not, such as a victim of a crime, must be personally present with such person at the time of the execution. So interesting. This is persons unauthorized. I wonder who this would be referring to. Can't quite see that footnote there. I don't think it translated through. Was it in 8? Kirby versus Beto, 1970, Fifth Circuit. Jeez. All right. That would be an interesting case to look up. All right, so we're on to, section 302, time of execution. Let's pop over here to the chat real quick. And Bill Thomas says that a recent case where a judge enacted the search was found to be improper because the judicial branch may not execute the search. True. Wow. Yeah, I think I recall hearing that one. Somewhere, I think, around West Virginia, if I'm not mistaken. I hope it's the same one. Otherwise, it means there's more than one happening that we know about. All right, here's time of execution. A judge requested to issue a search warrant, has discretion in fixing the time within which the warrant may be served, subject only to the statutory provisions fixing the maximum time for the execution of a warrant. When a warrant is not executed within the time fixed by the issuing magistrate, it becomes void. So if there's a fixed time, interesting thing to pay attention to. Some statutes fix a time limit within which a search must be made, while other statutes provide that the search must be made forthwith. And still, other statutes do not provide any time limit for the execution of a warrant. So check your state statutes. Under a statute providing that a search warrant must be executed within 10 days, the issuing magistrate may provide for a lesser time of execution in the warrant. But if no such limitation is provided, it may be executed within 10 days after its issuance. So some states will have this prescribed or proscribed, whatever. Observation. A statute requiring a search warrant to be executed within 10 days of its issuance does not automatically permit the executing officer to delay the execution up to the maximum time within his or her discretion, but rather, if the warrant is executed within 10 days, the government need make no showing of timeliness, although the defendant may still show that the execution was untimely. Interesting. In the absence of a statute, the courts are careful to refrain from indicating any specific number of days as being a reasonable time for the execution of a search warrant, as what constitutes a reasonable time depends upon all of the circumstances of the particular case. However, because search warrants are directed to existing violations of law and not to violations which occur in the future, an officer executing a search warrant should execute it promptly. They're existing violations of law, not something which will occur in the future. So it should be executed promptly. And under a statute requiring an immediate execution of search warrants, and another statute requiring that a return of search warrants be made not later than 7 days from the date of issuance, a warrant must be executed within a reasonable time, and no search warrant may validly be executed more than 7 days after its issuance. So that's under a particular state statute, and that's footnote 8, Massachusetts, 1974. So it seemed the 70s was a pretty busy time regarding cases and search warrants and seizures. I think that was kind of the beginning of the war on drugs, wasn't it? Coincidence? All right, section 303, delays in execution. The purpose of the statutory requirement of the timely execution of search warrants is to ensure that probable cause still exists to believe that the items sought by the warrant are in the place to be searched. Now, you see how this is? The purpose of any statutory requirements for timely execution is to ensure that the probable cause will still exist to believe that the items sought by the warrant are in the place to be searched, that they're still there. A delay in executing a search warrant may thus render stale the probable cause finding. Thus, an unconstitutional delay in the execution of a warrant may occur, notwithstanding that the execution occurs within the time set by rule or statutes. And whether a delay in executing the warrant is unconstitutional depends on whether the probable cause recited in the affidavit still exists at the time of execution of the warrant. So this brings us back to our last presentation in which we're going over the constitutional challenges. And when you're trying to make a constitutional challenge, it's something that should be challenged as soon as possible. So as we're seeing here, an unconstitutional delay in the execution of a warrant may occur, notwithstanding that the execution occurs within the time set by rules or statutes. So the argument wouldn't be about the rule or statute of a 10-day limit or such. It would be there was an unconstitutional delay. And that would be the primary argument. And that would give it a better bite as far as a constitutional case, it seems. All right. An unexplained delay of 42 days renders a search warrant invalid as a matter of law. 42 days. An unexplained delay of 42 days renders a search warrant invalid as a matter of law. That seems like 1968, State versus Baker, South Carolina. But a delay of 8 days in the execution of a search warrant is not, as a matter of law, unreasonable. And that was Florida, 1956, Joyner versus City of Lakeland. And U.S. versus Williams in the 8th Circuit, 1993. There is no unreasonable delay when a search is made on the day after the warrant is issued. When the delay is to protect the property, the date on the warrant is a typographical error, and the officers act in good faith. Ooh, wait a second. There's no unreasonable delay when it's made on the day after the warrant is issued. Yeah, you should have at least a day. When the delay is to protect property, that's reasonable. And the date on the warrant is a typographical error, and the officers act in good faith. Okay, good faith. And that's motion to quash grand jury subpoenas, 1984 in Southern District of West Virginia. Interesting. That looks like a very good case to look up too. All right. We're on section 304, places which may be searched. And before we do this, let's hop on over to the chat and see what we got here in the chat. Bill Thomas says, you may not search for the stolen bicycle in the pantry drawer of the homeowner. Hopefully. All right. So we're on here to places which may be searched. A search of a place not described in a search warrant is the equivalent of a search without a warrant and is unreasonable. Yeah, looking for the bicycle in the pantry drawer. When a search warrant limits the search to specific locations in a residence, a search of the entire residence exceeds the scope of the warrant. Observation. A search warrant authorizing the search of the dwelling of a named individual does not authorize the search of separate living quarters at the same address, or a search of another individual thought to be residing there. A search pursuant to a warrant describing a dwelling may include all outbuildings or vehicles located within the curtilage, an enclosed patio attached to the building, a garage. Search pursuant to a warrant describing a dwelling may include. However, if the warrant authorizes a search of a house without mentioning outbuildings either in the warrant itself or by incorporating such reference in the affidavit, a search of the outbuildings may be outside the scope of the warrant. And here's our practice tip. When executing a search warrant for documents, the searching agents are entitled to at least curiously examine each document at the specified search location. Cursorily. All right, one more time. When executing a search warrant for documents, the searching agents are entitled to at least cursorily examine each document at the specified search location. Wow. That's a lot of documents. As to the propriety of issuing only one search warrant to search more than one place or premises. See section 227. And here's a supplement we have on some cases, which is always nice. So here are supplement cases. Father of a resident's son was occupant, in quotations, of resident's home, with meaning of warrant for search of residence, which extended to vehicles parked near residence, if such vehicles could be specifically connected to occupants of residence, where he regularly stayed. There and his possession of keys and regular presence demonstrated control. Wow. Father of resident's son. Wow. Was occupant of okay. Any unlocked or locked container on the premises that could reasonably conceal an item described in the warrant may be opened and searched. Wow. 2010 in Massachusetts. Terrible. After defendant's sister gave valid consent to warrantless search of her home, officers had authority to seize defendant's shoes, which were in plain view in the bathroom in which the defendant was showering, and defendant's clothing and identity cards in the home's washing machine, which was covered by the sister's valid consent to search it. It was not necessary to obtain defendant's consent to seize his property. Wow, don't give out consent. Wow. All right, so we're on to section 305. Persons who may be searched. A warrant to search only an owner-occupant's premises does not necessarily authorize a search of the owner-occupant, even if he or she is found on the premises. As a general rule, an officer executing a search warrant does not have the right to search a transient visitor who arrives at the premises being searched while a search is in progress, who does not reside inside the dwelling or have a property interest in the dwelling, and who is not named in the search warrant as a party to be searched under color of the search warrant. Under a warrant to search an apartment and seize certain stolen goods, officers have no authority to search a person unexpectedly found there and to seize contraband found on such person. If the search warrant authorizes the police to search any persons on the premises at the time of service of the warrant, they may search individuals who arrive at the residence named in the warrant after the police have began executing that warrant. And here's our practice tip. Pay attention. A statute that permits the officer executing the search warrant to detain or search any person in the place at the time does not limit the officer's right to search persons as to whom probable cause for a warrantless search exists. Ugh. That's Moody versus State, 1998 in Georgia. Lord. All right. And let's get on to the next section here. And we're going to get over to searches and seizures generally. And before that, let's hop on over to the chat here. And Bill Thomas asks if I wonder if the files on electronic devices count as documents in these rules. Well, that case was not too old. Let's go back here and take a quick look, because I think let's see, persons. What was that one? That was persons. I think it was the one previous, wasn't it? Let's see here. Documents. Practice tip. When executing a search warrant for documents, the searching agents are entitled to entitled at least cursorily examine each document at the specified search location. So each document that's there, and that's footnote 9, and that is 1997, Southern District of Florida. we'll have to look at this one here. 1997. Were those electronic files? Likely not. Those are probably paper documents. However, let's see. This is a 2011 supplement we're reading right here. So let's see, a 2006. This would be an interesting one for research. I'm sure there's been some more recent case law on this, and I'm sure if I were to get the newer edition of this, we might find something about that on there. But thanks for the question. All right, let's proceed here. All right, we're on to searches and seizures, section 306 generally. In the absence of express statutory provisions as to the method of service of a search warrant, officers are limited only by the constitutional inhibition against unreasonable searches and seizures. Although the United States Constitution does not specifically direct the manner in which search warrants must be executed, the execution of a warrant will withstand an attack on constitutional grounds only if it does not amount to a breach of the constitutional mandate that the people be secure in their persons, houses, papers, and possessions from all unreasonable searches and seizures. If the manner of the service of a search warrant does not subject the defendant to unreasonable treatment, it will meet the requirements of law and justice. The test of reasonableness under the Fourth Amendment in the context of executing a search warrant is an objective one. That's footnote 4, Los Angeles County, 2007. It is incumbent on the law enforcement officer executing a search warrant to ensure that the search is lawfully authorized and lawfully conducted. An officer's conduct is subject to scrutiny for reasonableness from the moment of entry to conduct the search until the moment of departure. In executing a search warrant, law enforcement officers may take reasonable action to secure the premises and to ensure their own safety and the efficacy of the search. Good Lord. That's footnote 7. Los Angeles County, 2007. Again, Rattel. This is a case that needs a little bit of investigation, it seems. When law enforcement officers execute a valid search warrant and act in a reasonable manner to protect themselves from harm, the Fourth Amendment is not violated. The officers executing a search warrant may reasonably rely on a warrant's validity. The execution of a warrant is not unconstitutional if it is objectively reasonable for the officers executing the search warrant to have relied on the issuing judge's determination that probable cause existed. The Fourth Amendment is not violated by a mistaken execution of a valid search warrant on the wrong premises. However, it is unreasonable for officers to assume that neighboring property is the same as that described in a warrant, when the distinction between the property described in the warrant and the neighboring curtilage is abundantly apparent. That's interesting here. The Fourth Amendment is not violated by mistaken execution of a valid search warrant. However, it is unreasonable for officers to assume that neighboring property is the same as the one described in a warrant when the distinction is abundantly apparent. An officer executing a search warrant must be able to identify the things to be seized with reasonable certainty. The officers executing a search warrant have some discretion as to the items to seize, so long as the warrant minimally confines their discretion by allowing them to seize only the evidence of a particular crime. If the executing officers flagrantly disregard the limitations of a search warrant, an otherwise constitutional warrant is transformed into a general search. Get that? If executing officers flagrantly disregard the limitations of a search warrant, An otherwise constitutional warrant is transformed into a general search. Law enforcement officers executing a search warrant have a duty to conduct a search in a reasonable manner and avoid unnecessary damage to property of innocent third parties. Thus, destruction of property that is not reasonably necessary to effectively execute a search warrant violates the Fourth Amendment. To avoid a Fourth Amendment violation, any destruction caused by law enforcement officers in the execution of a warrant or arrest warrant must be necessary to effectively execute that warrant. So any destruction caused by law enforcement officers in the execution of a search or arrest warrant must be necessary to effectively execute that warrant. Footnote 18, and that's Cuyahoga County, 1997, 7th Circuit, 1998. All right, so late 90s. Officers may detain all residents or occupants of a dwelling or office in a single room during the execution of a search warrant, even if the detention lasts several hours. Goodness gracious. A police officer's authority to detain incident to a search is categorical, and it does not depend on the quantum of proof justifying the detention or on the extent of the intrusion to be imposed by the seizure. So the authority to detain incident to a search is categorical, and it does not depend, so it's by that category, and there's not a level or a quantum and a quantity and amount of proof. It does not depend on a particular amount to justify that detention or an extent of the intrusion to be imposed by the seizure. That's interesting here, and that's footnote 20, and that's Mueller versus Mena, 2005. Looks like Connecticut. Yikes. Police officers executing a search warrant of a house seeking weapons and evidence of gang membership in the wake of a drive-by shooting acted reasonably by detaining an occupant in handcuffs for 2 to 3 hours while the search was in progress, as the governmental interest in handcuffing the occupant was at its maximum in view of the nature of the material sought, thus outweighing the occupant's interest in being free from the additional intrusion effected by the handcuffing, especially since only 2 officers were available to watch over the occupant and 3 other detainees. Well, I guess it kind of makes sense. That's footnote 21. Back to Mueller versus Mena, 2005, Connecticut. And we're on to the supplement here with some more cases. Law enforcement officers' large-scale 4-day search of a farm pursuant to valid search warrant was reasonable rather than unnecessarily destructive under Fourth Amendment requirements, even though some livestock bolted through fence and lost weight, kitchen stoves left on, and pregnant cat gave birth, but some kittens died. Oh, they killed the kittens. Since cattle spooked, bolted, and broke through the fence immediately upon officers' arrival at the farm, which was a necessary part of executing the search warrant, and farmers were denied entry into house, turn off stove, and check on cat in order to prevent possibility of farmers concealing objects of search. Jeez, 2010. Goodness gracious. When neutral magistrate had determined police have probable cause to believe contraband exists, neutral magistrate, connection of occupant to home alone justifies detention of that occupant during execution of search warrant. Constitutional rights that law enforcement officials may not violate are not lessened merely because law enforcement officials elect to execute a search warrant with a SWAT team. Jeez. Merely because they elected to execute a search warrant with a SWAT team. Jeez. Ohio. And here we're on to section 307, exhibiting or delivering a warrant or copy. Unless a statute or court rule provides otherwise, an officer executing a search warrant is not obliged to exhibit the warrant as a prerequisite to the right to execute it. That's under some statutes of some courts. Unless a statute or court rule provides otherwise. An officer executing a search warrant is not obliged to exhibit the warrant as a prerequisite to the right to execute it, nor is the officer required, in the absence of statute, to read the warrant to the person against whom the search is directed. Rather, the warrant is executed by making the search. Wow. So the actual doing of the search. That's odd there. Neither the Fourth Amendment nor the rule governing the issuance of search warrants imposes a requirement that the executing officer present the property owner with a copy of the warrant before conducting a search. A state constitution may require police officers to have a copy of a search warrant with them at the time they conduct a search, but does not require the entire warrant be shown, read to, or understood by an individual who may be present and whose property is about to be searched. A procedural rule may require that an officer leave a copy of the warrant with the person or persons on whom the search warrant is served. And here's an observation. Search warrant procedures do not contemplate that the person to whom a warrant is presented should be able to judge from the presentation at the time of its execution its full legality, and perhaps decide that on that basis whether to comply. Rather, they are intended to notify that person that the officers have been authorized to be in that particular place and to search for that particular thing. So the procedures are not to contemplate whether the person is to be presented the warrant. Rather, the search warrant procedures are intended to notify that person that the officers have been authorized to be in that particular place and to search for that particular thing. Interesting. That's 2007. Again, Massachusetts. The U.S. Constitution protects property owners, not by giving them license to engage the police in a debate over the basis for a search warrant, but by interposing ex ante the deliberate, impartial judgment of a judicial officer between the citizen and the police, and by providing, ex post, a right to suppress evidence improperly obtained, and a cause of action for damages. So, ex post, after the fact, you have remedy. And that's what it's designed to do, because it protects by not giving them license, but it protects property owners, right? As long as there's not going to be any debate about the basis for the search warrant at that time, but by interposing ex ante the judicial officer's decision there. And if it seems wrong that ex post you have a right to suppress the evidence so that the penalty can't be inflicted, and a cause of action for damages and remedy in that respect. But that's the Constitution. Under the federal rules of criminal procedure, an officer taking property under the authority of a search warrant is required to give a copy of the warrant and a receipt for the property taken to the person from whom or from whose premises the property was taken, or leave a copy of the warrant and receipt at the place where the officer took the property. State officers executing a search warrant without any significant federal involvement are not subject to this federal rule. So that's a federal rule of criminal procedure about leaving that notice behind. When the jurisdiction does not require the warrant to be exhibited, it is not necessary that the police actually have the search warrant in their possession when entering to conduct a search. Thus, the search of a residence is not invalid because a search warrant was not in the law enforcement agent's physical possession at the time of their entry. That's pretty heavy there. And we're on to section 308, which sums up what we were just reading there too. But before we do that, of course, let's check back to the chat. And we have here what's normal. Hey, welcome. What's normal? Security compound, CCTV, barbed wire, canine to protect ourselves. Yeah. Well, exactly, and that's our right to do as well. Castles with moats. Freedom seeds. Indeed. Particular. Now, that's what they have to be able to do. Part of the procedures, and I think that's elements of law here, is that they have to mention particular what they're there to do and where they're supposed to be. And Bill Thomas says, I had the mistaken belief that a warrant must be presented prior to search in all cases. Thank you for showing me otherwise. Indeed. The remedy is ex post, after the fact, so interesting there too, but those are the laws of the land, so as that is, it's best just to take the precautionary thing. I think we had to me, the best suggestion is what's normal, because protect ourselves from malfeasant servants is probably the best remedy there in advance, because what I always say is preparation is the best form of prevention, and the prevention's always better than the cure. Let's continue. Oh, I passed it up. I realize we're already here. So jurisdictions requiring exhibition of a warrant. So, silver lining. In those jurisdictions in which a copy of the warrant must be served on the person in possession of the premises, personal service of the warrant on a person found within the premises at the time of the search protects both officers and occupants by discouraging resistance and informing those within the premises that the intrusion is under lawful authority. This looks like Oklahoma. It's one of those states. A statute calling for service of a copy of the warrant does not invalidate a search of premises on which no one is present or in occupancy. That's in Maryland, Tennessee. Interesting. Under a statute requiring that a copy of a search warrant be served upon the person in possession of the premises to be searched, such person does not waive the statutory requirement by consenting to the search. Wow. So even if you consent, it's not waiving that statutory requirement of them exhibiting it. Observation. A statute requiring an exact copy of the warrant be served on the person against whom the search is directed requires strict compliance, and it is insufficient if the copy with which such person is served is only a partial copy, although there is some authority to the contrary. And that's in 5, and that's US, let's see here, Maine. Wow. So we have a few states here. It looks like they have that statutory requirement there, Bill, for displaying or exhibiting that warrant, having some statutory requirement, right, to have the warrant served on the person, that they, of course, they have to be present for that to have effect. And also by consenting to the search doesn't waive that requirement, the statutory requirement by consenting. So that's an interesting caveat as well. All right, well, I think we've made it to the end of tonight's presentation, and that was nice to come up with the silver lining here as far as statutory requirements, and that gives us a little homework to do to find out if indeed your state has any kind of is a jurisdiction that requires exhibition of a warrant, which would definitely be a nice protection additionally layered upon our Fourth Amendment protections. And with that being said, I want to thank everyone for showing up here tonight and to learn about the warrants and searches and seizures. A lot of history in here. We're reading from the 2011 second edition of American Jurisprudence. Certainly there's been more recent case law or case citations and holdings that refer to this. However, some of these principles should still apply, and having a good overview of all this would help us interpret these requirements, statutory, lawful, constitutional, and otherwise, to ensure that all of our rights are fully exercised and secured as they should be here on America. So with that, I'd like to thank you all, and we'll see you all in the next one. Peace out.